If you found this video, someone probably told you the same thing they told me. Stay silent, don't answer questions. It's your constitutional right. And for most situations, that advice is solid. But there are 10 states in this country where that exact advice, delivered at the wrong moment, will get you handcuffed, charged with a felony, and stripped of your gun rights permanently. Not because you did anything wrong, because you said nothing. Here's what almost every concealed carrier believes. The Fifth Amendment protects you. Stay quiet, don't incriminate yourself, let your lawyer talk. It's the advice you've heard from gun channels, from forums, from guys at the range who've been carrying for 20 years. And they're not wrong in most contexts. The problem is that duty to inform laws don't care about the Fifth Amendment. They're a completely separate statutory requirement, and courts have upheld them without exception. So here's what I had to accept, and what I want you to hear clearly. Staying silent during a traffic stop in Ohio, Michigan, North Carolina, or 7 other states isn't exercising your rights. It's you committing a crime. The law doesn't just allow you to speak, it requires you to. And the carriers who end up charged aren't criminals. They're people exactly like you who thought silence was safe. I've spent months reviewing the actual statutes, court rulings, and documented arrest cases across all 10 of these states. By the end of this video, you'll know the exact law in each state, the real penalties that are currently being enforced, and the one professional disclosure phrase that satisfies every single requirement in every one of these states, without escalating the encounter. Let's get into it. Let's start with Michigan, because Michigan is where I see the most shock. Carriers who think they have a few seconds to assess the situation before disclosing. They don't. Under Michigan compiled laws, Section 28.425F, any licensee carrying a concealed pistol who is stopped by a police officer must immediately disclose they have a license and are carrying. That word, immediately, has been the centerpiece of multiple Michigan prosecutions. Here's the scenario that plays out constantly. Traffic stop. You're nervous, you decide to wait, see if the officer asks about weapons first. That 5 to 10 second hesitation has been successfully prosecuted as failure to immediately disclose. Michigan courts have upheld that immediately means before any other conversation begins, not after you hand over your license, before you say a single other word. First offense, $500 civil infraction. Manageable, right? But if the officer spots the weapon before you disclose it, the stop instantly escalates to a criminal weapons investigation. And one documented violation puts your permit under review. 2. And revocation is nearly automatic. Michigan isn't just strict, it's a preview of how every state on this list treats silence. The law doesn't assume good intent. It assumes you hid the firearm. And once that assumption takes hold, everything that follows is damage control. Here's where it gets worse, because the next state makes Michigan look lenient. Ohio, the state that changed the rules and didn't tell anyone. Ohio revised Code Section 2921.29 requires any person carrying a concealed handgun who is stopped for a law enforcement purpose. 2. Promptly inform the officer. Promptly means the moment the officer approaches your vehicle, not after they ask for your license. Your first words. What changed in Ohio, and what most carriers don't know, is that enforcement intensified significantly post-2022. Officers are trained to watch for disclosure. When it doesn't happen, you don't get a warning. You go from routine traffic stop to weapons investigation in seconds. Prosecutors have used failure to disclose, stacked with minor violations, to push plea deals that permanently strip gun rights. 3 concealed carriers in Ohio were charged with failure to disclose last year. They weren't criminals. They were people who thought staying quiet was their constitutional right. Ohio is the clearest example of how the gap between what you believe the law is and what the law actually is can collapse your life. And it's happening in real time, right now, to people who would be watching this video if they'd found it sooner. That's 2 states, but both of them only apply duty to inform when you're stopped. This next one, the officer doesn't even need a reason to stop you. North Carolina, the law that has no trigger, except an officer walking toward you. North Carolina General Statute 14-415.11 requires any permit holder carrying a concealed handgun to disclose to any law enforcement officer who approaches them for any purpose that they hold a permit and are carrying, not stops you, approach you, for any purpose. That means you're standing on a sidewalk, an officer walks toward you to ask for directions. Your legal obligation to disclose has begun. You haven't been stopped. you haven't been suspected of anything. The moment official contact is initiated, the requirement is active. In 2002, a Mecklenburg County man was cited after an officer approached him in a parking lot during a wellness check. He was legally carrying. He said nothing. Citation, court date, legal fees, permit suspension. Over $4,000 in total cost, and he never got his permit back. North Carolina's law is uniquely dangerous because it defies the intuition most carriers develop in other states. You're used to thinking, "Did I get stopped?" as the trigger. In North Carolina, that thinking will get you convicted. And if you think you're protected because your state has constitutional carry, no permit required, this next point is specifically for you. Missouri, Virginia, and the permitless carry trap. Here's the misconception that's spreading fast as more states adopt constitutional carry. No permit requirement means no disclosure requirement. It doesn't. And in Missouri and Virginia, this belief is causing real harm. Missouri has constitutional carry, but no universal duty to inform statute. However, once an officer observes a firearm before you've disclosed it, the stop converts immediately to a criminal weapons investigation. The officer has no way to verify your carry is legal until they've treated the situation as a threat. That means weapons drawn, orders to exit the vehicle, detention, sometimes arrest, all before a single charge is filed. Virginia eliminated its formal duty to inform requirement in 2021, but carriers traveling from duty to inform states into Virginia often assume their home state rules travel with them. Or worse, carriers from Virginia moving to Michigan apply Virginia's relaxed rules. The law of the state where you're standing governs your conduct. Your home state's rules end at the state line. Constitutional carry is a legal right. It is not a legal shield during officer contact. The moment you're interacting with law enforcement, your carry law and the officer contact law are two separate frameworks, and both apply simultaneously. We're halfway through. The next states are the ones most out-of-state carriers get caught in, and the penalty structures will surprise you. Indiana and Wisconsin, the transit states that catch out-of-state carriers. Indiana and Wisconsin are duty to inform states that disproportionately affect carriers who aren't residents because of geography. Indiana sits between Illinois, highly restrictive, and Ohio, strict duty to inform. Carriers transiting through Indiana frequently don't know Indiana has its own disclosure requirement under Indiana Code 3547215. I didn't know I was required to is not a defense. It has never worked in court. Wisconsin's penalty for first offense failure to disclose is $25. That sounds like nothing. But a Wisconsin violation is grounds for immediate license revocation, and Wisconsin shares violation data with other states. Your home state can revoke your permit based on a $25 Wisconsin fine. That $25 becomes a $3,000 legal battle to save your carry rights. If you cross state lines with a firearm, and many of you do regularly, you are carrying in a multi-jurisdiction legal environment. Every state you enter has its own rules. Ignorance of those rules isn't a gray area. It's just exposure. Here's the part where most gun channels would move on. I'm not, because Oklahoma and Louisiana have the fastest rising enforcement numbers in the country right now. Oklahoma and Louisiana, where enforcement is actively rising. Oklahoma adopted constitutional carry in 2019, but Oklahoma statutes, Title 21, Section 1290.8, still requires license holders stopped by law enforcement to disclose Louisiana Revised Statute 1379.3 requires permit holders to notify any officer of the weapon's presence and present the permit upon request. Oklahoma's first offense is a misdemeanor. The second is a felony. Most carriers in Oklahoma don't learn about the duty to inform requirement until after their first charge. In Louisiana, district attorneys have explicitly made weapons compliance a prosecution priority, which means these charges aren't being dismissed. They're going to trial. And Louisiana has mandatory sentencing guidelines that restrict judges from reducing charges after conviction. In both states, the arrests are coming from law-abiding gun owners who simply didn't know. That is the most preventable tragedy in this space. You can't comply with a law you don't know exists, which is exactly why this video exists. 2 more states, and these have the highest duty to inform arrest rates in the country over the last 24 months. Nebraska and Arkansas, the highest recent arrest rates in the country. Nebraska Revised Statute 692441 and Arkansas Code Annotated 5733315 both require immediate disclosure during any official law enforcement contact. Nebraska's law even applies when you initiate contact. If you approach an officer to report something, you must disclose that you're carrying. Nebraska's 2023-2024 enforcement data shows a consistent pattern. Most failure to disclose charges originate from stops where the officer observes the firearm before the carrier says anything. That creates two charges simultaneously: failure to disclose and carrying in a manner that creates a safety hazard for law enforcement. That second charge carries up to 18 months imprisonment. In Arkansas, failure to notify is a Class A misdemeanor, up to 1 year in county jail and a $2,500 fine. For a second offense, it escalates. And Arkansas's mandatory minimum sentencing guidelines significantly limit a prosecutor's ability to reduce the charge. The judge's hands are tied. Nebraska and Arkansas aren't outliers. They're the current leading edge of a national enforcement trend. Law enforcement agencies across these 10 states are receiving specific training on identifying non-disclosure. This is not passive enforcement anymore. It's active. Now, here is the only piece of this video that matters, if you take nothing else. The professional disclosure, the exact words that protect you in every one of these states. Every duty to inform law across all 10 states requires the same core thing: disclosure, identification, and compliance. None of them require you to surrender your firearm unprompted, reach for your weapon, or do anything that escalates the encounter. Memorize this. Practice it until it's automatic. Officer, for your safety and mine, I am required to inform you that I am a concealed carry permit holder, and I am currently armed. How would you like me to proceed? Every word works. For your safety and mine. Cooperative framing. Officers respond to this with immediate de-escalation. I am required to inform you. You know the law. You're not nervous volunteering. You're complying with a statutory requirement. That distinction matters in court. I am a concealed carry permit holder. Establishes legality. I am currently armed. Direct, clear, no ambiguity. How would you like me to proceed? Hands control to the officer. Prevents any movement that could be misinterpreted. Deliver this before the officer asks any questions, before you hand over your license and registration, before any other conversation starts. In all proactive duty to inform states: Ohio, North Carolina, Michigan, Oklahoma, Nebraska, Arkansas, Louisiana, Indiana, Wisconsin. This is your first sentence the moment the officer reaches you. After you deliver it, hands visible, ideally on the steering wheel. Do not move toward the firearm unless directed. If the officer asks to take custody of your weapon during the stop, comply calmly. You will get it back when the stop concludes. What you never do: reach toward the weapon without direction, fumble with a holster, offer to show the firearm, or make any movement toward it. The disclosure eliminates the danger. Movement toward the weapon recreates it. This phrase works in Texas and Illinois too, demand-based states, because over-disclosing in a state with no proactive requirement is not a crime. Under-disclosing in a proactive state is. The professional disclosure eliminates the variable entirely. You say it everywhere. You are always compliant. Full stop. Here's what we covered today. And more importantly, what it means for you every time you carry. 10 states, 10 different laws. One consistent pattern. Law-abiding carriers are losing their permits, their freedom, and their gun rights permanently, not because they did anything wrong, but because they said nothing at the wrong moment. Ohio requires your first words to include disclosure. North Carolina triggers on any officer approach. Michigan's immediately has been enforced to the second. Permitless carry in Missouri and Virginia doesn't protect you during officer contact. Indiana and Wisconsin are catching out-of-state transiting carriers. Oklahoma and Louisiana are actively prosecuting. Nebraska can hit you with 2 charges simultaneously. Arkansas has mandatory sentencing that ties a judge's hands. And through every single one of those scenarios, one sentence gets you through safely. Officer, for your safety and mine, I am required to inform you that I am a concealed carry permit holder, and I am currently armed. How would you like me to proceed? Practice it tonight. Say it in your car. Say it until it comes out naturally under stress, because stress is exactly when you'll need it. If this gave you something you didn't know before, subscribe. Every week, I break down the laws that actually affect how you carry, so you can do it confidently and legally no matter where you go. Next video: 7 states where your concealed carry permit is not honored, and crossing that state line with your firearm is a felony the moment you arrive. If you carry across state lines at all, that video is not optional. I'll see you there.